risen, disrupting the delicate ecosystems that sustain our fisheries, an essential source of food and livelihoods. More frequent and intense weather events have destroyed homes, decimated infrastructure, and left scars in the lives of our people that no amount of financial aid can truly heal. Hurricane Irma in 2017 was a turning point for our nation. The island of Barbados is 62 square miles. Irma, the largest recorded storm in the Atlantic at that time, was 375 miles wide when it thundered over the island with ferocious winds of 220 miles per hour. Barbados clearly did not stand a chance. If we were not a single state, the people of Barbados would have had to literally seek refuge elsewhere. They would have become climate refugees. My government for years sustained the livelihood of the people and rebuilt Barbados at an immense cost, adding significantly to our debt burden. While large, wealthy countries can borrow on their capital markets at 3% per annum, the so-called high-income SIDS, like Antigua and Barbuda, must borrow commercially at 10% to finance repeated rebuilding of infrastructure damaged by hurricanes caused by the failure of other states to mitigate emissions. Mr. President, the principle of prevention, a cornerstone of international environmental law, demands that states take action to avoid causing significant harm to others. Yet, global emissions continue to rise. As the threshold of 1.5 degrees Celsius is being crossed, the very existence of our small island states is threatened by this failure of polluting countries to act. No participant has disputed that greenhouse gas emissions emanating from human activity are causing and will continue to cause significant harm to the climate system, to populations globally, and to the environment. Nor does any participant dispute the conclusion of the global stocktake that current efforts are insufficient. Even now, the Loss and Damage Fund, which was recently established, has received only $700 million in pledges. And I emphasize pledges, not contributions. This pledge amount is wholly inadequate compared to the scale of climate-related losses our small countries are suffering. Antigua and Barbuda has worked tirelessly to address this crisis. At every conference of the parties, from Paris to Baku, we have joined with other vulnerable nations to demand action, to demand financing, and to demand justice. That advocacy has taken us to fora outside of the UNFCCC, to the UNGA, to IDLAS, and to creating the Commission of Small Island States on Climate Change and International Law, COSIS. We seek this advisory opinion not to point fingers, but to clarify the obligations of states under international law before the clock on our survival runs out. We ask, what must small states, or states generally, do under international law to protect the climate system for present and future generations? What is the responsibility of those whose actions have contributed disproportionately to this crisis? Antigua and Barbuda stands in solidarity with other vulnerable nations, particularly our fellow small island states. Together, we endure the worst of a crisis that we did not create. But today, we also stand with the millions across the globe who are looking to this court for a path forward, for clarity, for justice, and certainly hope. We believe in the power of international law to bring about change. This court's voice can inspire the urgent action that has eluded the political arena. It can remind the world that the rights of small nations, of vulnerable peoples, and of future generations are not secondary, but fundamental. The people of Antigua and Barbuda are counting on you. The world is counting on you. And I say here that this is not just a legal question. It is a matter of survival. Mr. President, I ask that you now call on Mr. Phillips, who will address the legal points. Thank you.
Gaston Brownie. I now give the floor to Mr. Phillips. You have the floor, sir.
Mr. President, members of the court, in order to assist the court, Antigua and Barbuda will address a select number of points. I begin with the Paris Agreement. The scale of the climate crisis was known as long ago as the 1960s. In a collective effort to combat climate change, states agreed on the climate treaties, most recently the Paris Agreement in 2015. Today, however, many high-emitting states attempt to rely on the climate treaties as a shield to escape accountability. Their approach to the Paris Agreement would deprive the most vulnerable of any redress. First, these states argue, in effect, that the obligations of the Paris Agreement are merely procedural. In other words, so long as a state ticks the box to identify a nationally determined contribution, or NDC, it has complied with Article 4 of the agreement. For these states, this is so even if both the ambition and the implementation of the NDC fall manifestly short of a meaningful contribution to ensuring that temperatures do not rise above 1.5 degrees. Second, certain of these states simultaneously argue that either the Paris Agreement displaces all other relevant rules of international law, including the customary obligation of prevention, or that compliance with Paris translates automatically to compliance with those other rules. These two arguments together would lead to a surprising conclusion that the climate change treaties leave the world and the most vulnerable states therein less well protected than if these treaties had never been concluded. This is a dangerously regressive approach. It is also erroneous for the following reasons. First, NDCs are not empty decorations. Under Article 4, each state must set its proposed contribution to a level corresponding to a fair share of remaining carbon budget to meet the 1.5 degree temperature goal. And they must take all measures at their disposal to achieve their proposed contribution. This understanding is further corroborated by a COP decision obliging parties to explain in writing how their NDC is both fair and ambitious in light of national circumstances, and how it contributes to the Paris temperature goal. Second, the customary obligation of prevention remains in any event applicable along with other treaty-related obligations. As the Chamber of the ICJ recognized in the LC case, the Court must not accept that an important principle of customary international law should be held to have been tacitly dispensed with in the absence of any words making a clear intention to do so. There is no evidence that the states in the climate treaties themselves or in their contemporaneous or subsequent practice intended to dispense with the existing legal protections. To the contrary, the UNFCCC confirms the continued relevance of both custom and treaty-based regimes. The climate treaties and other sources of law mutually reinforce and shed light on one another. Compliance with the Paris Agreement is necessary, but may not be sufficient for compliance with states' obligations under custom, UNCLOS, and human rights institutions. Antigua and Barbuda therefore agrees with the dozens of other participants in these proceedings, and the European Court of Human Rights and the ITLOS that Paris Agreement does not displace and instead operates harmoniously with the customary obligation of prevention and other relevant rules of international law. I turn now to the obligation of prevention. The attempt by a handful of participants to render this customary rule inapplicable is unconvincing. First, High-emitting states consistently attempt to distinguish between conventional transboundary harm, to which the obligation of prevention applies, and harm occasioned by the climate crisis, to which allegedly it does not. This contrived distinction has no basis in law or in fact. The large-scale nature of the transboundary environmental crisis does not carry it beyond the scope of international law. To the contrary, the protections of international law apply with added rigor. Second, some states attempt to argue that applying the obligation of prevention to climate change would require the emergence of new customary rules. This is wrong as a matter of law. It confuses the existence of a norm with its application to a given set of facts. There is no doubt that the general obligation to prevent significant transboundary harm exists in custom. International courts and tribunals can and must apply that norm when presented with specific facts. States have not excluded the application of existing customary norm to the climate change. To the contrary, climate treaties explicitly affirm the ongoing applicability of customary obligations. As to the content of the obligation, because high-emitting states have not acted and are not acting with the appropriate diligence in light of the nature of the risk and their capabilities and responsibilities, I will touch briefly on these elements. The severity of the risk cannot be overstated. With each successive IPCC report, our understanding of the magnitude of the risk has increased. We also know with scientific precision that the remaining carbon budget available to keep global warming under 1.5 degrees and the harms that will occur failing that. There is, in the IPCC's words, a rapidly closing window of opportunity to avoid catastrophic damage. The standard of diligence applicable to high-emitting states in this context is, in the words of ITLOS, stringent. Allocating a greater burden of emission reductions to high-emitting developed states is inherent in the notion of due diligence obligation. The Court has already accepted that the level of required diligence is premised on each state's capabilities. In the context of climate change, the level of required diligence is also differentiated based on each state's responsibilities. And this flows from the principle of CBDR-RC. The argument of certain high-emitting states that CBDR-RC has no role outside the climate treaties is plainly wrong. The UNFCCC requires its parties to be guided by the principle of CBDR-RC in their actions, both to achieve the Convention's objectives as well as to implement the provisions of the Convention. As a result, when states take action to achieve climate objectives, they must respect the principle of CBDR-RC, including when they are acting under the prevention obligation and human rights obligations. The European Court of Human Rights recently confirmed this interpretation. Seeking a harmonious interpretation across legal regimes, the European Court relied on the principle of CBDR-RC outside the climate treaties, specifically in the context of states' due diligence. States' due diligence obligations to mitigate greenhouse gas emissions from their international human rights obligations. Taking these elements together, the obligations of states are clear. To act with diligence, states must make rapid, deep, and sustained cuts to national greenhouse gas emissions in light of the remaining carbon budget. They must do so taking into account the evolving level of risk and their respective capabilities and responsibilities. The IPCC, which produces the best available science, also stressed the importance of carbon budgets and identified the remaining budgets for keeping within the 1.5 degree limits, as each state must use not more than an equitable share thereof, with developed states taking the lead. It necessarily follows that, firstly, a developed state must do its utmost, using all means at its disposal, to reduce its emissions considerably more than 43% by 2030, 60% by 2035, 69% by 2040, and 84% by 2080 compared with 2019 levels. To achieve a net zero CO2 emissions well before 2050 and net zero greenhouse gas emissions well before early 2070. Second, a developing country must still contribute, but its equitable share may be less demanding depending on the past and present emissions and the level of development and capabilities. Some states emphasize that there is yet no internationally agreed equitable share of the carbon budget, but we say this is not an excuse. The absence of an agreed methodology for apportioning shares simply means that there is a corresponding obligation to cooperate to reach that agreement. In the absence of an agreement, a diligent state must develop its own methodology to determine its equitable share using the best available science in good faith recognition of its own capabilities and responsibilities. Moving to the second question, state responsibility. All participants accept two principles. First, a breach of international obligation automatically gives rise to state responsibility. And second, the content of that responsibility, namely the state's duty to make reparation, depends on the existence of harm and a causal nexus between the breach and the harm. The application of the second principle in the case of climate change, however, is where some participants differ. While the harm caused by climate change is well established, some participants argue that the necessary causal link cannot be proved. They contend that the causal complexity makes it impossible for an obligation to make reparation to arise in respect of a wrongful emission. In other words, they ask the court to sanction a situation of breach with no responsibility to make reparation for it. That would be, in the language of the Trail Smelter Award, a perversion of fundamental principles of justice to deny all relief to the injured person and thereby relieve the wrongdoer from making any amend from his acts. When the court has been faced with similar arguments, it has consistently rejected them. It has first reaffirmed that even though the state of science regarding the causal link between the wrongful acts and the damage may be uncertain, that will not automatically preclude the existence of a duty to make reparation. Second, it has identified principles to accommodate uncertainties in assessing the existence, extent, and cause of harm. The court should affirm this approach in this present case. It is useful to examine how causation is accommodated in the rules governing existence, content, and extent of state responsibility. As a first step, determining the existence of an internationally wrongful act requires that conduct constitutes a breach of an international obligation which is attributable to the state. For the obligation of prevention, a state must have failed to use all means at its disposal to prevent emissions emanating from within its territory or subject to its jurisdiction from resulting in significant harm to the environment. The court has confirmed that causation does not play a key role in determining a breach of this type of obligation. States are under a duty to act, which is not dependent on the certainty that the action taken will succeed in preventing the relevant harm, or even has a likelihood of doing so. On this basis, both the ITLOS and the European Court of Human Rights have rejected the so-called drop-in-the-ocean argument that no state can have breached due diligence obligations in the context of climate change because no single state's emissions reductions measures could make a meaningful difference in this crisis. The second step is to identify the content of state responsibility. There will be a duty to make reparation where there is first, injury, and second, a causal relationship between the wrongful act and the injury. Both conditions are capable of being fulfilled in the context of climate change. First, the existence of the injury is axiomatic. In these proceedings alone, scores of states will describe the injury that they have and continue to be suffering. For some small island states, injury rises to the level of compromising their continued existence. Second, the causal link between the wrongful conduct and harm is capable of being satisfied in individual cases. This is because it is scientifically possible to determine a state's contribution to global warming, and because principles exist to address remaining areas of causal uncertainty. This includes the flexibility of the applicable causal standard. The Court has affirmed that causation must be sufficiently direct and certain, with sufficiently being a relative concept that takes into account the particular circumstances. Indeed, in the armed activities case, the Court confirmed that the causal nexus required may vary depending on the primary rule violated and the nature and extent of the injury. The Court should confirm that approach in this present case. As an illustration of this flexible standard, in armed activities, the Court adopted a presumption of causation. It held that it was for the breaching state to establish that a particular injury was not caused by its failure to act within the diligence to prevent certain conduct of individuals within its territorial control. The same presumption applies by analogy in respect of wrongful emissions from a state's territory that are clearly contributing to the climate change harm. This would be complementary to the scientific proof of causal connections between specific states' emissions and harm, and could be one way to address remaining causal uncertainties. A number of participants argue to the contrary, that it is not scientifically possible to satisfy the causal link between a state's wrongful emissions and harms sustained so that a duty to make reparation would arise. These states are wrong, but they are also asking the Court to find, as I have already noted, that states may be responsible for breaches of international law, but that there will be no obligation to make reparation. This would prejudge or even prevent the commencement of future cases. To ask the Court to go to such lengths is remarkable. What these states are primarily concerned about is being held responsible for more than their fair share in a situation where there are concurrent causes of harm. But that concerns the extent of the duty to make reparations, not whether that duty exists at all. As the Court has held, the fact that damage was the result of a concurrent causes is not sufficient to exempt a responsible state from any obligation to make reparations. The third step concerns the extent of responsibility. International law has mechanisms that deal with apportionment of the duty to make reparations across multiple states. The armed activities case, again, is instructive. The Court confirmed that in certain cases where multiple causes result in an injury, responsibility for part of such injury should instead be allocated among those actors or causes. These principles, supported by scientific techniques, allow the Court to best approximate the relevant state's share of responsibility in light of contributing factors. In sum, causal complexity in the context of climate change is no bar to the existence, content, or extent of state responsibility, including a duty to make reparations. Antigua and Barbuda respectfully urges the courts to give particular credence to the views of small island developing states, especially affected states, on the applicability of the duty to make reparations in the context of the climate change crisis. Mr. President, members of the court, Antigua and Barbuda thanks you for your time.
I thank the representatives of Antigua and Barbuda for their presentation. I now invite the next participating delegation, Saudi Arabia, to address the court, and I call upon His Highness Prince Jalawi Turki Al Saud to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the court, it's a great honor to appear before you in these important proceedings and to do so on behalf of the Kingdom of Saudi Arabia. As a country particularly vulnerable to extreme heat, weather scarcity, desertification, and other adverse effects of climate change, the Kingdom acknowledges the urgency of taking action to mitigate the harmful effects of climate change. As a state with a resource-dependent economy, economic diversification objectives, and historically low greenhouse gas emissions, the Kingdom emphasizes the importance of international cooperation to advance global efforts to protect the climate system by addressing anthropogenic greenhouse gas emissions. At the same time, efforts to address greenhouse gas emissions must occur alongside efforts to ensure the fulfillment of the objectives such as energy security, energy affordability, poverty eradication, food security, and economic development, among other goals, in order to achieve sustainable development. Peoples around the world have historically had unequal access to energy and have made unequal contributions to atmospheric greenhouse gas concentrations. Those states that participated in the Industrial Revolution early on enjoyed advantages in welfare, infrastructure, and economic development. Having regard to state differentiated responsibilities and capacities requires recognition of different starting points, development needs, and social context. The response will not be uniform across countries and regions. The Specialized Treaty Regime on Climate Change, comprised of the United Nations Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement, address these complexities. Under the Specialized Treaty Regime, the Kingdom actively participated in negotiations and contributes to the response of climate change. The Kingdom's response includes nationally determined contribution, as well as several ambitious initiatives, such as the Saudi Green Initiative and the Middle East Green Initiative. Additional details on the Kingdom's efforts and initiatives are in our written statement. Mr. President, allow me to highlight 3 important points. First, the Specialized Treaty Regime on Climate Change provides a complete answer to the question on obligation and consequences. Second, the Specialized Treaty Regime on Climate Change is a remarkable achievement. It is specifically designed to address the complex global phenomenon on climate change. It was reached through determined and rigorous negotiations and guided by the multilaterally agreed principles. The treaty regime reflects the good faith efforts of all participating states to reach pragmatic and effective agreement on what are immensely complex policy matters for every state. Third, to impose any obligations or consequences that go beyond or conflict with those contained in the Specialized Treaty Regime on Climate Change would risk undermining the integrity of this regime and impaired future progress in international efforts to protect the climate system. Mr. President, our next speaker will be Sir Michael Wood, who will address you on the role of the court and the applied law. He will be followed by Ms. Ghaida Bajaba from the Saudi Ministry of Energy, who will speak to the application of the 2 questions put by the General Assembly. Mr. President, members of the court, I thank you for your attention. I request that you invite Sir Michael Wood to the podium.
I thank His Highness Prince Jalawi Turki Al Saud. I now give the floor to Sir Michael Wood.
Mr. President, members of the Court, it's an honour to appear before you and to do so on behalf of the Kingdom of Saudi Arabia. In the time available, I must be selective. We maintain and attach importance to all the points in our written statement and written comments. The fact that we do not cover certain points made by others does not mean that the Kingdom agrees with all that they say. Mr. President, I shall address the Court's role in these proceedings, as well as the applicable law. We urge the Court to adopt a cautious approach when answering the two questions posed by the General Assembly. The need for caution was addressed in the General Assembly debate upon the adoption of Resolution 77-276, when many states emphasised that it was not for the Court to impose additional obligations or responsibilities on states. The consensus among states at the General Assembly was based on a clear understanding of the role of the Court and the scope of the questions. Mr. President, members of the Court's role in advisory proceedings, as in all of its work, is to apply the lex lata. This is particularly so given ongoing negotiations among states pursuant to the specialised treaty regime on climate change to further advance global efforts to protect the climate system by addressing anthropogenic greenhouse gas emissions, negotiations which are based on state sovereignty and on consent. Despite some calls that seem to be urging the Court to impose new obligations, advisory proceedings cannot be a substitute for negotiation. An effective and progressive response to the threat of climate change requires active and good faith negotiation and cooperation among states based on states' own policy choices and on their consent. Such choices are not matters that courts can impose from above. The specialised treaty regime on climate change contains a well-established framework that governs states' negotiation and cooperation, providing the Court with the basis for addressing the questions before it. This regime establishes a legitimate mechanism for stabilising greenhouse gas concentrations in the atmosphere, precisely because it is based on the clear consent of states. A judicial response that departs from the lex lata and alters the specialised treaty regime on climate change would undermine the credibility and effectiveness of the existing legal regime and the framework for negotiation, cooperation and consent that the treaties establish. Mr. President, members of the Court, the chapeau added by the General Assembly to the questions in Resolution 77-276 lists a series of instruments, duties, rights and principles, some applicable, some not. In any event, it is not for the General Assembly to determine what law is applicable to answering the questions put to the Court. The chapeau cannot have an effect on the Court's function of determining the applicable law. In the recent Occupied Palestinian Territory opinion, after setting out a rather similar chapeau, the Court went on to make clear that, and I quote, "The Court will determine which rules of international law are relevant for answering the questions posed proposed by the General Assembly." End quote. Jura novit curia. It is for the court to determine the applicable law. I now turn to the applicable law that is relevant to the questions put by the General Assembly. All participants accept that, under international law, states' climate change obligations are primarily governed by the specialised treaty regime on climate change. It is fundamental that the Court reaffirms the primacy of this specialised treaty regime, since it reflects the consensus of states on how to address the global threat of climate change. Some, however, seem to be suggesting that it is the scientists that determine states' legal obligations. That is not so. It is the treaties, not scientists, that set out legal obligations. One other important point that I should make is the coherence of the specialised treaty regime. Contrary to certain suggestions, the Kyoto Protocol, the Paris Agreement, and other instruments and measures developed exclusively under the UNFCCC enhance the implementation of the UNFCCC and build upon the principles and provisions established in the UNFCCC. Mr. President, members of the Court, that concludes my short statement, and I request that you now invite Ms. Ghaida Bajba to the podium. I thank you, Mr. President.
I thank Sir Michael Wood. I now give the floor to Ms. Ghaida Bajba. Madam, you have the floor.
Mr. President, members of the Court, my name is Ghaida Bajba from the Ministry of Energy. It's a great honor to address you and to do so on behalf of the Kingdom of Saudi Arabia. In response to question A, I shall first address certain aspects of the specialized treaty regime on climate change. The importance of nationally determined contributions, NDCs, certain fundamental principles of the treaty regime and its primacy. I shall then say a word about the interpretation of the specialized treaty regime, which cannot be expanded by reference to other instruments. And finally, I should offer some thoughts on question B. Mr. President, members of the Court, the Kingdom and other participants have described in detail in their written pleadings the specialized treaty regime on climate change. Among other things, all states have a binding obligations to prepare, communicate, and maintain their NDCs, taking into account common but differentiated responsibilities and respective capabilities and national circumstances. While the NDC process is mandatory, the content, implementation, and achievement of the NDCs themselves are not legally binding. States have full discretion to determine their NDCs. That is intentional. That deliberate choice for voluntary contributions by states is central to a proper understanding of states' obligations, referred to in the questions before the Court. NDCs concern an obligation of best efforts, not of result. The specialized treaty regime on climate change is based upon certain fundamental principles. I only have time to mention two and refer you to the Kingdom's written pleadings for further details. First, the principle of common but differentiated responsibilities and respective capabilities. As is universally recognized, the atmospheric concentrations of greenhouse gases contributing to climate change date back to emissions from the Industrial Revolution. This historic responsibility is recognized in the treaty regime. Second, the treaty regime emphasizes stabilizing atmospheric greenhouse gas concentration in a time frame that expressly enables economic development to proceed in a sustainable manner and on the basis of equity, and in the context of sustainable development efforts to eradicate poverty. These principles are the bedrock of the treaty regime, essential for many states to be able to join the negotiating consensus. It is important that they are clearly affirmed in the Court's opinion. The Kingdom believes there is no room to play down the primacy of the specialized treaty regime on climate change and overlook the crucial importance of the worldwide acceptance of the regime. The Paris Agreement's requirement for the parties to identify and maintain NDCs is a carefully designed mechanism for advancing progress towards the Paris goals. Almost every state has submitted an NDC. This is a significant achievement. The specialized treaty regime on climate change provides no basis for the Court to recommend limits on fossil fuel extraction and production. No basis whatsoever. The specialized treaty regime requires parties to consider actions necessary to meet the specific needs and concerns of states not listed in Annex 1 to the UNFCCC and affected by response measures to climate change, including those with economies highly dependent on fossil fuel production and export. Failure to respect these provisions would undermine the carefully negotiated balance under the specialized treaty regime that accommodates the diverse economic circumstances of all parties. Perhaps most critically, the Court should not interrupt the treaties in a way that goes beyond what was agreed by the negotiating states. This is particularly so with respect to aspirational provisions, such as the temperature goals in Article 2 of Paris Agreement, which do not impose legally binding obligations. Some participants argue that scientists should determine states' obligation. That, with respect, cannot be the case. As stated previously, it is the treaties that set the obligations. Nothing would threaten future progress in international effort to protect the climate system more than distorting and misrepresenting agreed language. Apart from the specialized treaty regime, none of the treaties or instruments mentioned in the chapeau to the questions was intended to address climate change. These instruments were not designed to address the unique challenges presented by the climate change. This is the case in the Law of the Sea Convention, which has been considered by states in the context of the advisory proceedings in Hamburg. We set out at some length our considered positions on ATLAS advisory opinion in our written comments. In short, the law of the sea cannot be interpreted as imposing obligations that are inconsistent with or go beyond those agreed in the specialized treaty regime. Mr. President, members of the Court, the principle of international environmental law and international human rights law referenced in the chapeau were not developed in the context of climate change or agreed by states in the specialized treaty regime. They are not applicable to the questions before the Court. Nor can the application of notions such as harmonization or systematic integration serve as basis for imposing wholly new or inconsistent obligations on states with respect to climate change. The no-harm principle was not designed to apply to the protection of the climate system from greenhouse gas emissions, nor does it do so. It concerns transboundary environmental damage caused directly by activities in the territory of one state to the territory of a neighboring state. As several participants have observed in their written pleadings, The no-harm principle applies in a bilateral context where there is a clear link between the source of harm and the affected state. The principle doesn't apply whereas here, anthropogenic climate change results from a whole range of varied and diffuse activities and events that emit greenhouse gases accumulating over a long period of time. Some participants have referred to a right to a safe, clean, healthy and sustainable environment. But as we and others have explained, such a right hasn't entered the corpus of international law, and the implications flowing from any such right haven't been spelled out and agreed. The obligations under human rights treaties also do not address the protection of the climate system from anthropogenic greenhouse gas emissions. It is important to note that international human rights obligations apply only to the states parties to the particular treaty, and then only in respect to individuals in their territory or under their jurisdiction. The statements of human rights bodies and special rapporteur do not affect this position. As the court recalled in the Qatar versus United Arab Emirates case in connection with the Human Rights Convention, and I quote, "The interpretation must be based above all on the text of the treaty." End of the quote. Decisions of regional or domestic courts and tribunals are not source of general international law. There are many reasons for this, primarily, of course, because national or regional courts are usually applying national or regional law, including domestic constitutional law or regional human rights law. Even when they seek to apply public international law, they may do so through a domestic or regional lens. Mr. President, members of the court, I now turn to question B. Like question A, question B doesn't ask the court to seek to qualify the activities that resulted in emissions. It was clear when the questions were asked that there were no intention for the court to consider the responsibility or liability of individual states. As we and others have explained in our written pleadings, the climate change treaty regime contains its own compliance mechanism to deal with the legal consequences where a significant harm is caused. In addition to mitigation and adaptation requirements, the treaty regime contains a loss and damage mechanism which seeks to deal with cases of harm. Mr. President, members of the court, as you are aware, a loss and damage fund has already been established. Where a party considers that another party has breached its obligation, it may invoke the relevant compliance and dispute settlement mechanisms, including under Article 15 of the Paris Agreement. This provision establishes a mechanism to facilitate implementation of and promote compliance with the Paris Agreement. Some argue for application of the residual rules of customary international law on state responsibility, as proposed by International Law Commission. However, as many participants have recognized in their written pleadings, there are significant problems with applying these residual rules in the present context. Above all, there are highly problematic questions of causation. In any event, Article 55 of the Articles on State Responsibility provides that they do not apply where and to the extent that the conditions for the existence of an internationally wrongful act or the content or implementation of the international responsibility of a state are governed by special rules of international law. The specialized treaty regime on climate change itself determines the legal consequences of significant harm to the climate system. Finally, with respect to point 2 in question B, the specialized treaty regime doesn't, The specialized treaty The specialized treaty regime doesn't confer rights upon individuals. Moreover, as others have also made clear, the concept of peoples and individuals of future generations is too indeterminate for them to have legal status or standing, or for claims to be made on their behalf. Mr. President, I would like to conclude with 3 points. First, the Kingdom of Saudi Arabia respectfully requests the Court to answer questions A and B by confirming that state obligations to protect the climate system and other parts of the environment from anthropogenic greenhouse gas emissions are those set out in the specialized treaty regime on climate change. And the legal consequences under the obligations are to be determined by reference to the specialized treaty regime on climate change. Second, determining obligations that are inconsistent with or go beyond those agreed in the specialized treaty regime would undermine the ongoing and future progress in international efforts to protect the climate system. Third, to strengthen the global response to the threat of climate change, the Kingdom is committed to the full implementation of the principles and obligations embodied in the specialized treaty regime, UNFCCC, the Kyoto Protocol, and Paris Agreement. Mr. President, members of the Court, that concludes the oral presentation of the Kingdom of Saudi Arabia. We thank you for your attention. I thank you, Mr. President.
I thank the representatives of Saudi Arabia for their presentation. I now give the delegation of Australia to invite the delegation of Australia to address the Court, and I give the floor to Mr. Jesse Clark.
Mr. President, Madam Vice President, distinguished members of the Court, it is a great honour to appear before you on behalf of Australia. Climate change is one of the defining challenges of our time. Australia is resolutely committed to taking urgent action to address the effects of anthropogenic greenhouse gas emissions on the climate system. In that context, Australia was proud to co-sponsor the United Nations General Assembly resolution requesting an advisory opinion from this Court. Climate change is the greatest shared threat to all countries. It is having significant impacts, in particular on small island states, and these impacts will only increase as the temperature of the planet rises. Indeed, climate change poses the single greatest threat to the livelihoods, security and well-being of the peoples of small island states, including Pacific island states. Australia commends the long-standing leadership of our Pacific neighbours in shaping global responses to climate change and, in particular, Vanuatu's leadership in driving forward the request for this advisory opinion, together with the core group. Australia is committed to working with the Pacific to strengthen the global responses to climate change. Global cooperation is critical to delivering an effective response to climate change. Australia acknowledges the extent of the challenge posed by climate change and recognises that ambitious individual and collective action must be undertaken urgently. In this regard, the UNFCCC and the Paris Agreement are the central instruments that provide the framework for international cooperation and commitments to tackle the grave challenge of climate change. Collective action under these treaties has resulted in a reduction over time of projected future levels of greenhouse gas emissions. However, parties are not yet on track to ensure the objective of the UNFCCC and the goals of the Paris Agreement are met. Australia recognises there is an urgent need for states to take stronger individual action now to achieve our collective goals, which is even more pronounced today than it was in 1992. Unless greenhouse gas emissions peak and rapidly reduce in the near term, we will experience rapid warming and more pronounced changes to sea levels, river flow, water temperature and precipitation. To maximise the chance of meeting the temperature goals of the Paris Agreement, the world's largest emitters, which have not yet peaked and begun to reduce their emissions, must rapidly do so. Australia is taking urgent and ambitious climate action to reduce greenhouse gas emissions, decarbonise its economy, strengthen national and regional adaptation, and increase resilience to the impacts of climate change. Australia is resolutely committed to achieving the objective of the UNFCCC and the goals of the Paris Agreement, including by strengthening its emissions reduction targets, legislating a commitment to achieve net zero by 2050, and delivering on its climate finance commitments. The questions before you provide an important opportunity for the Court to clarify the existing legal obligations of all states and the particular legal consequences for all states with respect to climate change. The Court has not been asked to opine on the international responsibility of or consequences for any specific state or group of states. In particular, question B does not require or invite the Court to determine whether breaches of any such obligations have occurred or will occur, nor whether particular states are specially affected or injured. Australia observes that there are many areas of consensus among the participants to these proceedings. In particular, there is broad agreement on the competence of the Court to render an advisory opinion in this matter, the central role played by the UNFCCC and the Paris Agreement in setting out states' obligations to address climate change, and the need to address the complex challenges of climate change on the basis of best available science, as most recently reflected in the 6th report of the Intergovernmental Panel on Climate Change. Australia was also pleased to see strong consensus on the need for international cooperation and increased ambition in collective responses to climate change. By way of outline, the Solicitor General of Australia will address the UNFCCC and the Paris Agreement, and the relevance of customary international law and the United Nations Convention on the Law of the Sea. Dr. Parlett will address you on question B as regards legal consequences. I thank the Court and, Mr. President, request that you now pass the floor to the Solicitor General.
I thank Mr. Clark. I now give the floor to Mr. Stephen Donny. Sir, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, it's a great honour to appear before you again on behalf of Australia. There is broad consensus amongst the participants in these proceedings on the central role of the UNFCCC and the Paris Agreement to the questions before the Court. The preambular language to both treaties describes climate change as a common concern of humankind, and consistently with that statement, these two treaties have near universal participation. They are the primary source of states' obligation under international law in respect of climate change, setting out both collective goals and aims alongside individual obligations and commitments. They create the central cooperative framework for the collective action that is needed to address both the causes and the impacts of climate change. The first global stocktake under the Paris Agreement showed that parties have made significant progress but are not currently on track to achieve the goals of the Paris Agreement. Importantly, however, the Paris Agreement has built-in mechanisms to address this, because each party must set an NDC every 5 years, which represents a progression beyond its last NDC, is informed by the outcome of the global stocktake, and which reflects the state's highest possible ambition. The global stocktake sets out clear next steps to address the gaps in climate ambition and implementation, including first, encouraging parties to set ambitious next NDCs that are economy-wide, cover all gases and sectors, and are aligned with limiting global warming to 1.5 degrees, as informed by the latest science. And second, setting new collective energy efforts to triple renewable energy capacity and double the annual rate of energy efficiency improvements by 2030, and to transition away from fossil fuels in our energy systems. The outcomes of the global stocktake demonstrate the dynamic process the climate change treaty regime creates for assessing progress and for adjusting action over time. The differentiated obligations of parties to the UNFCCC and the Paris Agreements, and the capacity of those obligations to adjust in light of parties' evolving national circumstances, and as best available science continues to inform the steps required to respond to climate change, underlies their status as the primary source of relevant legal obligations. Australia recognises that other treaties contain obligations that are relevant to the protection of the climate system, or that play an important complementary role alongside the climate change treaties. These include UNCLOS, international environmental treaties, sector-specific agreements that address specific types of anthropogenic greenhouse gas emissions, and international human rights treaties. Australia also recognises that the duty to cooperate under customary international environmental law is applicable to states' actions to address climate change. In respect of the relationship between the climate change treaties and other areas of law, Australia makes two observations. First, contrary to the submissions of some participants, it is not necessary for the Court to have regard to the rule of lex specialis, which is primarily focused on the resolution of normative conflicts in relation to the complementary obligations that exist under international law for the protection of the climate system. Second, this Court should promote a harmonious interpretation of states' obligations to protect the climate system from greenhouse gas emissions. As such, where other treaties and customary international law also impose obligations relevant to the protection of the climate system from climate change, those obligations must be interpreted consistently with those that have been carefully negotiated and agreed by the vast majority of states under the UNFCCC and the Paris Agreement. In this context, Australia emphasises that the rule reflected in Article 31(3)(c) of the Vienna Convention on the Law of Treaties addresses a situation where rules of international law external to a treaty are relevant to its interpretation, but does not operate to incorporate obligations from one treaty or from customary international law into another treaty. I turn next to the relevance of customary international law. The vast majority of participants, including Australia, recognise that the principle of prevention is a rule of customary international law that applies to significant transboundary harm. There is, however, divergence in relation to whether this principle applies to environmental harm caused by anthropogenic greenhouse gas emissions. Some participants suggest that the principle of prevention is of general application and therefore applies to harm caused by greenhouse gas emissions. Australia respectfully submits that the principle of prevention does not apply to harm of that kind for two reasons. The first reason is that greenhouse gas emissions are materially different from the conventional case of transboundary harm. Yet it is only in the context of those conventional cases that the court has applied the principle of prevention. Those conventional cases involve a direct and temporally proximate cause of environmental harm from an identifiable source spreading from one state to a neighbouring state, such as discharge of pollution into a river or discharges of noxious gases near the borders between states. That was the context in pulp mills, where the court held that a state is obliged to use all the means at its disposal in order to avoid activities which take place in its territory or any area under its jurisdiction, causing significant harm to the environment of another state. More recently, the court again applied the principle of prevention to claims of significant harm to the environment of an adjacent state in construction of a road. In Australia's submission, the unique nature of the mechanism by which greenhouse gas emissions cause harm to the environment provides an important point of distinction from cases of ordinary transboundary harm. Specifically, harm from greenhouse gas emissions arises by reason of the cumulative build-up of greenhouse gases in the atmosphere over a long period of time, being emissions which many different states and countless private actors are responsible. Furthermore, the harm that results is widespread rather than localised and may be experienced in places far removed from the source of emissions that contributed to its occurrence, rather than simply in neighbouring states. That combination of circumstances means that greenhouse gas emissions give rise to novel challenge in applying the requirements of causation of significant harm and in the determination of responsibility for specific impacts. The second reason that the principle of prevention does not apply to harm caused by greenhouse gas emissions is that there is no consistent or widespread state practice or opinio juris to confirm the existence and content of obligations deriving from the principle of prevention in that context. The divergence in views is clear from the views expressed by states participating in this very proceeding. This point is confirmed by the fact that when the international community addressed the obligations of states concerning greenhouse gas emissions through the UNFCCC and the Paris Agreement, it did not incorporate either the substantive or the procedural obligations that the court has found to be derived from the principle of prevention in conventional cases of transboundary harm. Instead, it developed more tailored and adjustable mechanisms to address the greater complexity of greenhouse gas emissions. For these reasons, to extend the principle of prevention to greenhouse gas emissions would not account for the unique features of the global challenge that such emissions pose. Such an extension would also be unsupported by the requisite state practice and opinio juris. Given the widespread adoption of the specialised climate change treaties, customary international law should not be held to have developed in a way that imposes obligations with a different content. If, contrary to our primary submission, the court concludes that the substantive aspect of the principle of prevention does apply to greenhouse gas emissions, compliance would be assessed against a standard of due diligence. That being so, Australia's view, which it shares with several participants in this proceeding, is that the UNFCCC and the Paris Agreement specify what that standard requires for states party to those treaties. Equally, compliance with those treaties will also satisfy the procedural aspect of the principle, such as obligations regarding cooperation and information sharing. As the very purpose of the UNFCCC and the Paris Agreement is to embody the agreements of states as to the measures that are appropriate and necessary to address greenhouse gas emissions and their environmental impacts, compliance with those agreed measures entails compliance with any customary international law obligations arising from the principle of prevention. Finally, I turn to UNCLOS. The vast majority of participants, including Australia, recognise the relevance of obligations arising under UNCLOS for the protection of the climate system. There is broad consensus that Part 12 of UNCLOS applies to pollution of the marine environment by anthropogenic greenhouse gas emissions, with the consequence that such emissions may enliven a number of obligations under that part. As a framework agreement, UNCLOS in many instances leaves the development of specific rules and standards to competent international organisations and specific sectoral agreements. In the context of climate change, those standards and rules are found in the UNFCCC and the Paris Agreement, to which the vast majority of states that are party to UNCLOS are also party. In those circumstances, Australia submits that Part 12 of UNCLOS should not be interpreted as imposing obligations with respect to greenhouse gas emissions that are inconsistent with or that go beyond the obligations agreed in the specific climate change treaties. Otherwise, the agreements of states to very general obligations in Part 12 of UNCLOS would cut across the more specific agreements of those same states as to how they should individually and collectively address the harm caused to the whole environment, including the marine environment, by greenhouse gas emissions. Australia welcomes the recent ITLOS advisory opinion and the contribution it has made to clarifying the obligations of states to protect and preserve the marine environment from the impacts of climate change. Australia fully participated in those proceedings, and it recognises and respects the important role of small island states, including Pacific Island states, in requesting and obtaining that opinion. Australia wishes to highlight 5 key observations of ITLOS, which are consistent with the views of a number of participants in this proceeding and with the submissions that I have just made concerning UNCLOS. First, that greenhouse gas emissions constitute pollution of the marine environment within the meaning of Article 114 of UNCLOS. Second, that as the primary legal instruments addressing the global problem of climate change, the UNFCCC and the Paris Agreement are relevant to the interpretation and application of Part 12 of UNCLOS. Third, that the obligation to protect and preserve the marine environment under Article 192 of UNCLOS applies to the adverse impacts of climate change, and that the UNFCCC and the Paris Agreement are relevant to the measures to be taken to give effect to that obligation. Fourth, that the obligation to prevent, reduce and control pollution of the marine environment under Article 194(1) of UNCLOS imposes a due diligence obligation of conduct requiring best efforts, the content of which is variable and context-specific and may evolve over time. And fifth, ITLOS held that, given the diffuse and cumulative causes and global effects of climate change, it would be difficult to specify how greenhouse gas emissions from activities under the jurisdiction and control of one state cause damage to other states. Australia makes 2 final points with respect to UNCLOS. With respect to Article 194(1), Australia contends that the UNFCCC and the Paris Agreement are the standards that the international community has agreed to prevent, reduce and control damage to the environment from greenhouse gas emissions and keep a 1.5 degrees future within reach. In respect of Article 194 sub 2, the same points that Australia made in relation to the unique nature of the harm caused by greenhouse gas emissions, which I've just addressed in the context of the inapplicability of the principle of prevention to such emissions, also apply in relation to Article 194(2). If accepted, those points have the consequence that the effects of greenhouse gas emissions are not within the scope of Article 194, sub 2 of UNCLOS. Thank you for your attention, Mr. President. I ask you to invite Dr. Parler to conclude Australia's submissions.
I thank Mr. Donoghue. I now give the floor to Ms. Kate Parler. Madam.
B asks the court to consider the legal consequences in relation to a hypothetical situation in which a state has caused significant harm to the climate system. This invites consideration of two questions. Has an internationally wrongful act been committed? And if so, what are the legal consequences of that wrongful act? These questions refer to issues that are governed by customary international law as reflected in the International Law Commission's Articles on State Responsibility. However, as numerous participants have recognised, whether a breach of international law has occurred and its legal consequences are both context-specific questions. They are not amenable to resolution in the abstract. The answers will necessarily depend on the particular obligation that a state is alleged to have breached and the particular factual circumstances. Australia therefore submits that the United Nations General Assembly and states would be best assisted by an opinion in which the court identifies the issues that would need to be considered and assessed in order to determine, in a specific context, whether a breach has occurred, and if so, its legal consequences. Such clarification would provide valuable guidance to participants, given the divergent views that have been expressed in these proceedings. A large number of participants have recognised that causation poses particular challenges in relation to climate change. As the court noted, in certain activities, issues of causation must be addressed as and when they arise in light of the facts of the case at hand and the evidence presented. Some participants have, however, asked the court to make generalised findings as to how difficulties relating to causation could be avoided. Australia submits that these general propositions should not be adopted by the court in its opinion. I will mention four by way of example. The first proposition is that a state can obtain reparation on the basis that injury has been caused to the climate system generally. However, for an obligation to make reparation to arise under customary international law, there must be a causal nexus between the wrongful act and an injury suffered by the claimant state specifically. In the absence of that causal nexus to an injury to a claimant state, there can be no basis for reparation. The second proposition is that the test for factual causation of injury in the context of reparation should be something lower than a but-for test. There is no sound basis for the application of a lower threshold in relation to all breaches of obligations relating to climate change. The court has applied the but-for test in relation to due diligence obligations of prevention. The authorities that are said to support a lower threshold, in fact, address different issues. They relate to causation in the different context of breach. They relate to legal causation, that is, remoteness and proximity, rather than factual causation, or they relate to proof of the extent of the injury, rather than proof of causation of injury. The third proposition is that there should be a presumption of causation in relation to climate change. However, in this context, there is no basis for reversing the general rule that a state seeking reparation must prove causation of injury. The onus of proof was reversed in the armed activities case because the respondent state was the occupying power of the relevant territory, and therefore it was in a better position to establish the relevant facts. The court emphasised the limited nature of that reversal, affirming that for damage alleged to have occurred outside the occupied territory, the burden of proof remained with the applicant state. The circumstances in which the onus was reversed in that case are not analogous. Fourth, as regards the potential application of Article 47 of the Articles on State Responsibility. That article does not apply to the conduct of states that contribute to climate change, such that the responsibility of an individual state could be invoked in relation to the wrongful conduct of states as a whole. The conduct of each state would be a separate internationally wrongful act, and based on current scientific understanding, those separate acts contribute to the same indivisible injury. Whether and how any responsibility to make reparation for that injury is to be apportioned is not addressed in the Articles on State Responsibility. And in these proceedings, the Court does not have before it sufficient material to determine the existence, scope and content of any rule of customary international law or general principle of law that governs such a situation. Of course, this is not to suggest that the rules reflected in the Articles on State Responsibility have limited utility in relation to climate change. Rather, it is to acknowledge that the challenges raised by causation are complex and cannot be resolved in the abstract and for all possible cases in these advisory proceedings. To conclude, Australia reiterates its commitment to addressing the significant threat posed by climate change at home and globally, and urges all states to accelerate global climate action to keep a 1.5 degrees of warming within reach. The Court has an important contribution to make in clarifying the obligations of all states to address climate change. Mr. President, Madam Vice President, members of the Court, I thank you for your kind attention.
I thank the representative of Australia for their presentation. Before I invite the next delegation to take the floor, the Court will observe a break of 15 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite the next participating delegation, the Bahamas, to address the court, and I call Mr. Leo Ryan Pinder to the podium. You have the floor, sir.
Mr. President, honourable members of the court, as the Attorney General, it is a privilege to appear before you on behalf of the people of the Commonwealth of the Bahamas in these historic proceedings. Present and future generations of Bahamians face an existential threat from climate change. It is virtually certain that 2024 will be the hottest year in history, and it is likely to be the first year when global warming exceeds the critical 1.5 degrees centigrade threshold. This heat has tangible and significant impacts on my people. More than 75% of all coral patches experienced some level of bleaching in 2023. This year, we had the earliest Category 5 hurricane ever recorded in the Atlantic. Our people and our economy are still reeling from the devastating effects of Hurricane Dorian, a Category 5+ storm that could have only been formed because of the climate crisis. We have more than 50 years of IPCC data that concludes that climate change is a threat, an imminent threat for small island developing states like my country. The IPCC tells us that extreme weather will only increase in frequency, intensity, and scale. International law plays a pivotal role in directing states' conduct to help save countries like mine. The court has a historic opportunity to shape this conduct through its advisory opinion. The Bahamas is disproportionately affected by climate change. We are one of the world's largest archipelagos, with more than 700 coral islands and 2,400 keys. To give you some context, our archipelago's exclusive economic zone is approximately the size of France. 80% of our land lies less than 1.5 meters above sea level. 80%. A sea level that is rising at an alarming rate, forcing us to recalibrate and adapt. Hurricanes and storm surges rip through our communities, bringing death and destruction. Rising sea levels and warming oceans decimate our coastal ecosystems, such as mangroves and seagrass, which used to provide a natural climate defense for our islands. Allow me to give you a few examples of how climate change affects the Bahamas. First, climate change has significantly altered weather in our region, making hurricanes more frequent and destructive. As a small island state in the Atlantic hurricane basin, we are particularly vulnerable. In 2021, the Climate Risk Index ranked the Bahamas third in the world for the most affected by weather-related events. All of our islands and all of my people are at risk. Still fresh in our memory is Hurricane Dorian, which devastated the Bahamas in 2019. More than 200 people died, nearly 10,000 people were displaced, and over 9,000 homes were destroyed. One of our more populated islands, both Abaco and Grand Bahama, were particularly hard hit. 75% of the dwellings in Abaco alone were damaged, and nearly 1/3 were completely destroyed. You could easily mistake this photograph for a pile of rubbish. However, what you are looking at are lost homes and lost livelihoods. A 20-foot storm surge rushed through the streets of these islands, contributing to approximately $3 billion in economic damage. That's about 25% of our annual GDP in just 2 days. The results of such a storm are real. They include displaced people, learning loss, livelihoods lost, and missing loved ones. All because some countries have ignored the warning signs of the climate crisis. Secondly, the Bahamas is a big ocean state who relies heavily on the resources of the sea, which have been under acute threat from climate change. The blue economy alone accounts for 40% of our economy. Oceans are absorbing a large amount of greenhouse gas emissions from the atmosphere, making them warmer and more acidic. This leads to the destruction of critical ecosystems, including our coral reefs, our mangrove forests, our seagrass, and our fish stock. That in turn affects our people's livelihoods, it reduces our biodiversity, and has ripple effects through the ecosystems which lose their protective properties. I ask you, who is going to retrain our fishermen when the fish are gone? And what is going to replace our tourism industry when the reefs and the beaches are gone? The Bahamas seagrass and mangroves are critical carbon sinks, mitigating the impacts of a warming planet. The Bahamas has 40% of the world's seagrasses. This vital climate mitigating asset are being destroyed at an alarming rate. Seagrass in the Bahamas has declined 1 to 2% each and every year, and extreme weather events have destroyed over 90% of viable mangroves in the Bahamas, all because industrial countries have ignored their obligations. We are currently witnessing the largest ever recorded mass coral bleaching event. The Bahamas is home to 5% of the world's coral reefs and the world's third longest barrier reef. Third, sea levels are rising and they will continue to rise, presenting an unprecedented challenge to the very survival of our nation. We are experiencing the effects due to decades of neglect by industrial countries. But long before our territory is submerged, we will feel the impact. We will feel coastal erosion. We will feel the flooding impact, salinization of our freshwater resources, and displacement of our vulnerable communities. By 2050, the Bahamas is projected to lose nearly 60% of its shoreline, the largest loss of land projected in the entire Caribbean region. By 2100, we will lose all of our sandy beaches in the Bahamas, all because warning signs have been ignored for generations. Excellencies, we experienced the threat of storm surges coupled with the rise in sea level resulting in catastrophic flooding. The slides above show a grave impact of flooding that would occur caused by a storm surge with 1 meter, just 1 meter of sea level rise because of a hurricane impact. In a Category 3 storm, which is the middle slide, more than 50% of the island will be flooded. This is the capital of Nassau, where 2/3 of our population live. A Category 5 hurricane, which is the one on the far right, will result in nearly the entire island of Nassau being underwater. This is the reality in which we live. This is why we need action, and we need it now. The Bahamas is at risk of being uninhabitable due to the severe impacts caused by the historical and present neglect of regulatory enforcement. Mr. President, honorable members of the Court, the world knows exactly what needs to be done, and the industrial countries have neglected it for decades in the interest of profits. It is time for these polluters to pay. The IPCC has been telling us for years that the only way to stop a warming planet is to make deep, rapid, and sustained cuts in the global greenhouse gas emissions. The world needs to reach net zero emissions by 2050, which requires a cut in the GHG emissions by at least 43% in the next 5 years. Industrial states need to take urgent action now and provide reparations for their decades of neglect. International law imposes robust individual obligations on states to mitigate their greenhouse gas emissions. Climate change is not some unstoppable force that individual states have no control upon. We must cut through the noise and accept that those whose activities have led to the current state of global affairs must offer a response that is commensurate with the destruction that has been caused. There is no parity, there's no fairness, there's no equity if those responsible continue to pass the buck. We insist on liability and we demand reparations. As I conclude, allow me to introduce two important principles. The principle of common but differentiated responsibilities recognizes the differing responsibilities of states to address climate change. And although we endorse this principle, it is not a get-out-of-jail card. Major emitters who self-identify as developing states cannot continue their current trajectory of greenhouse gas emissions. Each state is required to do everything possible to stabilize our climate system. All major emitters must effect deep, rapid, and sustained reduction of their greenhouse gas emissions. Otherwise, my people's suffering is only going to continue to increase. Equitable climate action must account for the disparity of impact on small island and low-lying states such as the Bahamas. Our climate systems do not recognize man-made boundaries, only the destruction. In the Bahamas, we see it in the mental health of our citizens. We see it in the repairing of roads, utilities, vital infrastructure. We see it in the lost workdays of our people. We see it in the learning loss of our children when they can't go to school. We see it as a revolving door of preparation, impact, and recovery. And then we reset that cycle. We prepare again, we have an impact, and then we recover again. And despite the hijacking that we witnessed at COP29, climate treaties such as the Paris Agreement make clear that developed states have obligations to provide financial and technical assistance to vulnerable states such as the Bahamas. I make one observation on the principle of sustainable development, which the Court has endorsed as early as 1997 in Gabachukovo-Nadamurash judgment. I have been struck by the statements of states which invoke the so-called right to development as a justification to pursue unconstrained energy policies. The Bahamas also invokes the right to development. However, our development is and has been hindered by states who refuse to act against climate change. International law does not stand for that. One person's development cannot be another person's destruction. Instead, international law aims at the full realization of human rights for all people, and that includes my people in the Bahamas. Excellencies, I call on you not only to reaffirm the principles set out in the International Tribunal of Law of the Sea advisory opinion, but to go further. We must extend these principles to enable real, enforceable action and reparations, not just a continuation of false promises. The devastation is undeniable. If we continue on our current path, my country will cease to exist. And then, Your Excellencies, I ask the question, who then will take my people? when their country does not exist anymore. We are not just speaking about numbers or projections. We are speaking about lives, cultures, and histories at risk of being erased completely. Let us act boldly, and let us act decisively. Let us act for my people in the Commonwealth of the Bahamas, and frankly, let us act for all people around the globe. I want to thank you, Mr. President and honourable members of the Court, for this esteemed privilege of appearing before you today on this very important issue. And I now ask the Court for you kindly to invite Dr. Conway Blake to address you. Thank you very much.
I thank Mr. Pinde, and I'll give the floor to Mr. Conway Blake.
Mr. President, honourable members of the Court, it's a privilege to be before you on behalf of the Commonwealth of the Bahamas. The Bahamas has submitted 2 rounds of written submissions, and I refer you to those for a full account of our pleadings. Today, in the interest of time, I will focus on one issue: the binding nature of states' individual obligations to mitigate climate change. You have heard already, and will hear time and again, that these obligations are limited, that they do not have teeth, that they are impossible to establish as a matter of law, and that they reflect political aspiration rather than firm commitment. That is, with respect, wrong. Yes, climate change raises difficult legal and evidentiary issues. And yes, it may well be impossible at this stage to prevent fully the environmental harm from greenhouse gas emissions that are already accumulating in the atmosphere. As the agent for the Bahamas has already explained, we are witnesses to growing catastrophic harm every day. But international law does not allow states to avoid responsibility for their actions just because legal compliance is difficult. It requires the opposite. It requires that states do their utmost to minimize future harm, to adapt to harm that we know is coming, and to cooperate in pursuit of those aims. In the time available to me, I will briefly address states' individual obligations to effect deep, rapid, and sustained reduction of greenhouse gas emissions, both under customary international law and under the climate treaties. I first turn to customary international law. The applicable rule of law here is straightforward. As the Court wrote in 1949 in the Corfu Channel case, it is every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. This remains the law today. In international environmental law, this principle has evolved to require states to prevent activities in their territory that cause significant damage to the environment of other states. Historically, this duty was most visible in the context of harm that can be traced back to one, often neighbouring state, like pollution that travels down a river or fumes from a factory that float across a national border. But greenhouse gas emissions, which the climate scientists tell us are the key drivers of climate change, fall squarely within the scope of that duty too. Greenhouse gas emissions are obviously not wastewater or smoke, but they behave like them, in that their release by one state worsens the environmental and human conditions in another state. And the damage, as explained by the agent for the Bahamas, is not simply significant. For states like the Bahamas, it is existential. You will hear others say that the prevention obligation does not apply to greenhouse gas emissions. But there is no principal reason for such limitation. As the Court noted in Pulp Mills, the prevention obligation has its origins in the due diligence that is required of a state in its territory. The obligation applies generally and is not limited to specific activities or to the activities of neighbouring states. and rightly so. Our understanding of environmental harm and sources of pollution evolves as society evolves. And the science today is clear. The factual link between greenhouse gas emissions and serious harm to the environment is well established. Thus, when a state emits excessive greenhouse gas emissions, it is damaging the environment of other states. That is sufficient to trigger an obligation to prevent such harm. Now, it may be difficult to link a specific portion of greenhouse gas to specific harm. There is no question that that presents a challenge for courts, particularly when addressing consequential issues such as reparations. But those evidentiary issues do not negate the existence of the obligation in the first place, and neither do they negate a finding of breach when a state fails to fulfill its due diligence obligations. Evidentiary difficulties also do not negate state responsibility or the duty to provide reparations. On this important issue, I refer the Court to the Bahamas' written statements. Coming back to the prevention obligation under customary international law, the Bahamas submits that it has three essential characteristics. First, it requires states to act. The Bahamas accepts that the obligation does not require states to succeed in eliminating all harm, which may not be possible, but it does require states to act with due diligence, which in turn calls for ambitious action informed by the best available science. In the context of harm caused by greenhouse gas emissions, the IPCC has made it clear what needs to be done. States need to reach net zero emissions by the middle of the century, and to do so, they need to effect deep, rapid, and sustained reductions in greenhouse gas emissions starting now. Science must inform states' actions and policies in this regard. Second, the prevention obligation is onerous. It requires each state to use all means at its disposal to prevent transboundary harm from occurring. As the Court explained in pulp mills, the measures can and should include adopting and enforcing legislation, regulating the conduct of private actors, and promoting transparency and broad public participation in environmental matters. What is key is that the state's action is ambitious and effective to have a real chance of preventing harm to the environment. Third, the required standard of care reflects the principle of proportionality. As such, each state's mitigation action should be broadly proportionate to its share of global greenhouse gas emissions. When over 60% of emissions come from only 5 states, their mitigation obligations are particularly onerous. Of course, that does not release other states from their own obligations, but the scale of the required effort pales in comparison. In addition, as the agent for the Bahamas has already discussed, the proportional allocation of mitigation duties must reflect the principle of common but differentiated responsibility, which is well recognized in international law. But CBDR does not eclipse proportionality rule itself. It rather informs our assessment of what legal burden a state can reasonably bear given its developmental capacity. That is all I wish to say today on the prevention obligation. I now want to turn briefly to the role of the climate treaties. They also impose individual obligations on states to mitigate. And unsurprisingly, such obligations are consistent with the state's obligations under customary international law. I will touch upon 2 obligations under the Paris Agreement. First, Article 4.2 of the Paris Agreement requires states to prepare, communicate, and maintain successive nationally determined contributions, or NDCs. These NDCs are not an aspirational wish list, or a purely discretionary decision or an unguided exercise. Their setting is a matter of concrete binding obligations. Let us go back to first principle. Treaty obligations must be interpreted in light of the treaty's object and purpose. In the Paris Agreement, that is expressly stated in Article 2A. That is, to limit the increase in global average temperatures to well below 2 degrees above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees. The Paris Agreement, like all other treaties, must also be performed in good faith. So while states are not obliged to achieve the temperature goal, they are required to set their NDCs in a way that makes it possible to achieve the aim. To that end, NDCs must reflect a state's highest possible ambition and represent a progression over time and be informed by the decisions of the Conference of Parties and the outcomes of the global stocktake. Just a brief note here on the global stocktake, because the Paris Agreement expressly requires states to take it into account in their NDCs. The 2023 stocktake makes clear that states are not on track to achieve the temperature goal. States must therefore urgently take steps to set and meet NDCs that can in fact result in deep, rapid and sustained reduction in global emissions in line with the 1.5 degree goal. That is what good faith requires. States' obligations under the Paris Agreement do not, however, end there. Article 4.2 also requires that states pursue domestic mitigation measures with a view to meeting their NDCs. This is not an obligation to actually meet the NDCs in all circumstances, but it requires that states act with diligence and pursue domestic policies which are reasonably aligned with their NDCs. One critical tool in the state's arsenal is the regulation of private actors who generate a considerable portion of greenhouse gas emissions. And I refer the Court to the Bahamas' written submissions, which discusses this obligation in more detail. In sum, states must diligently pursue mitigation measures in line with their NDCs, which in turn must reflect states' progress or indeed their lack of progress towards the temperature goal. There is no other way of interpreting the Paris Agreement without doing grave violence to the fundamental principles of treaty interpretation or international law. At this juncture, it is worth noting that other rules of international law also give rise to mitigation obligations. These include the law of the sea and human rights, both of which enshrine binding norms on the protection of the environment. Earlier this year, ITLOS affirmed states' obligations to prevent and reduce marine pollution in the form of greenhouse gas emissions. In the human rights sphere, there is no shortage of judicial decisions affirming states' obligations under international law. I commend those decisions to the Court and refer the Court also to the Bahamas' written submissions on these matters. Mr. President, Excellencies, before I conclude, there is one final point I will mention briefly, and that is the interrelation of these various bodies of law applicable to climate change. It should be clear by now that they do not stand in opposition to each other. They are complementary and they reinforce each other. The idea, for instance, that the climate treaties alone are exhaustive of states' climate obligations has no support in the text of those treaties, in the history of their negotiations, or in their very purpose. The climate treaties refer to both human rights and the prevention obligation. They did not erase existing public international law, and those who claim otherwise provide no credible support for their proposition. The Court should resist such harmful attempts to dilute and distort international law. Mr. President, Honourable members of the Court, you have the heavy burden of carrying out the Court's mission of upholding international law. That mission is urgent and necessary as we all face the existential threat of climate change. On behalf of the Bahamas and the present and future generations of people who share this planet, I implore you to be bold as you pen and deliver your opinion. It has been an honour to appear before you, and I thank you for your kind attention.
I thank the representative of the Bahamas for their presentation. I now invite the next participating delegation, Bangladesh, to address the Court, and I call upon His Excellency Mr. Tariq Muhammad to take the floor.
Mr. President, honourable members of the Court, Assalamu alaikum, and good afternoon. It is an honour for me to appear before you today as the agent of the People's Republic of Bangladesh. I start by expressing our solidarity with other specially affected states, including small island developing states, as our fates are linked in the face of increasingly devastating impacts of climate change. For Bangladesh, the consequences of climate change are more than existential threat. They are our lived reality. We have been ranked the 7th most climate-affected country based on number of fatalities, climate events, and economic losses. Bangladesh's unique geography and low-lying delta topography have shaped its cities and towns and influenced its culture for nearly 4,000 years. But today, they leave us especially vulnerable to climate hazards. As you can see on this slide, Bangladesh is situated between the Himalayas to the north and the Bay of Bengal to the south. More than half of our 170 million residents live in the Ganges Delta, the world's largest river delta, which lies no more than 5 meters above sea level at its highest points. And around 29% of the population lives in coastal areas with an average elevation of less than 1.5 meters. As a result, as depicted in this map, Bangladesh and its people face unprecedented catastrophe. Almost every part of my country is vulnerable to climate change impacts, including increasing salinity due to sea level rise, floods, cyclone and storm surges, severe weather and drought. The human impact of the climate crisis in Bangladesh is devastating. People are dying as a direct result of climate change impact, such as severe storms and floods, and because these impacts increase the prevalence of diseases and other health issues. Millions of people have already suffered the loss of their homes, businesses, schools, and in some cases, their entire communities. Millions more are at risk. These impacts are driving an unprecedented displacement crisis in Bangladesh. By 2050, the number of internal climate migrants could reach almost 20 million if temperatures continue to rise. Around 2,000 people are moving to Dhaka, the capital of Bangladesh, every day, which, as you can see from the slide, is also susceptible to severe flooding. The financial impact of climate change reflects the scale of the human tragedy. The annual cost of climate-related disasters in Bangladesh is $3 billion a year. On top of that, it is estimated that investments of more than 400 billion are needed to meet Bangladesh's mitigation goals and adaptation needs. The adaptation finance gap is, quote, very large, unquote, according to the Adaptation Gap Report of 2024. The reality is that my beautiful country and its people are victims of a grave injustice and fundamental inequity. Our contributions to historic global emissions are negligible, barely 0.5%. Yet, we suffer the worst impacts. We, therefore, require climate justice now. We have been resilient in the face of this devastation, but we cannot address these issues alone. Climate vulnerable states require a fundamental shift in the conduct of high emitter states who are not doing enough to address climate change or its impacts. Recent reports from the World Meteorological Organization indicate that global average temperature exceeded 1.5 degrees Celsius for much of 2024. In the face of repeated disasters, it has become impossible to cope without compromising basic human rights and meeting the SDG obligations. We have witnessed the frustration, the lack of progress in the recently held COP29. The new collective quantified goal of $300 billion a year in climate finance falls woefully short of the amount needed. The countries which are victims of climate change manifested their frustration by staging a walkout. Even if NDCs are implemented, global temperature is set to rise to 2.8 degrees Celsius by 2100, which is a death warrant for the Mother Earth. The court has an essential role in redressing this injustice and clarifying the obligations of all states, especially the major polluters, in the face of this global crisis. Bangladesh has confidence in the court delivering a strong advisory opinion commensurate with the immense scale and gravity of the climate crisis. It cannot be the case that international law has nothing to say in the face of this existential threat to specifically affected states such as Bangladesh and to the whole of humanity. I turn now to Bangladesh's distinguished counsel, Professor Payama Khawan and Ms. Catherine Merfar, who will address mitigation and adaptation respectively. I thank you all.
I thank His Excellency Mr. Tariq Muhammad. I now give the floor to Professor Payama Khawan. You have the floor, sir.
Mr. President, distinguished members of the court, I'm honored to appear in this historic proceeding on behalf of the People's Republic of Bangladesh. I will be addressing the harmonization of the multiple regimes of international law referred to in the first question before the court. These different branches of international law are all from the same tree, and they all lead to a single overriding obligation, namely that all states must take the necessary measures to deeply and rapidly mitigate anthropogenic greenhouse gas emissions to avoid breaching the 1.5 degrees Celsius threshold, with the greatest burden falling on the developed and high-emitting states. As recognized in the reports of the IPCC and the Paris Agreement, holding the increase in global temperature to 1.5 degrees Celsius would significantly reduce the risks and impacts of climate change. This pivotal obligation arises from distinct but interrelated and mutually reinforcing legal regimes, including principles of customary international law on transboundary harm to the environment, the UN climate change regime, comprised primarily of the UNFCCC and Paris Agreement, and fundamental norms of international human rights law, including the right to development. And all are to be applied in conjunction with the principle of common but differentiated responsibilities. I will speak to each in turn. First, as the Court recognized in pulp mills, under customary international law, each state is under a core obligation to use all means at its disposal to prevent activities taking place in its territory that cause significant damage to the environment of another state. There is no doubt that greenhouse gas emissions cause significant, indeed catastrophic, transboundary harm. Their long-term and global impact in no way diminishes application of this fundamental principle. Moreover, as confirmed in the unanimous ITLOS advisory opinion on climate change, a stringent standard of due diligence applies in preventing harm to the marine environment. The core obligations under UNCLOS Part 12 reflect customary international law. There is no reason why a less exacting standard should apply to the environment as a whole. Second, while the UN climate change regime is critical to mitigation, it is not the last word on states' obligations. The obligations under those treaties are largely procedural. They simply require states to formulate and communicate nationally determined contributions reflecting their highest possible ambition, and to ensure that successive contributions represent a progression of efforts over time. Some have argued in these proceedings that this specialized regime is somehow self-contained or even lex specialis, with the consequence that international law cannot impose obligations that go beyond the Paris Agreement. That position is manifestly inconsistent with the strong presumption against normative conflict and fragmentation. As the Court noted in the right of passage over Indian territory case, treaties should be interpreted as producing and as intended to produce effects in accordance with existing law and not in violation of it. It cannot be that the Paris Agreement is intended to violate pre-existing obligations to protect the environment. It is notable that in 1993, the Court had created a chamber for environmental matters. It was discontinued in 2006 because, as President Higgins explained at the time, states understandably saw environmental law as part of international law as a whole. It cannot be that the intention of the Paris Agreement is to protect the planetary climate system by excluding international law as a whole, not least when our common survival is at stake. In the words of the ILC report on fragmentation, without the principle of systemic integration, it would be impossible to give expression to and keep alive any sense of the common good of humankind. Bangladesh notes further that for lex specialis to apply, there must be some actual inconsistency between norms. But there is no such conflict between the Paris Agreement and general international law. Simply put, the lex specialis argument is missing the lex. It was squarely rejected by ITLOS, and it should similarly be rejected by this Court. Mr. President, invoking the Paris Agreement to avoid pre-existing obligations is particularly troubling because the Earth has already reached a year-long temperature exceeding 1.5 degrees Celsius. There is obviously a substantial emissions gap. It cannot be that grossly inadequate NDCs somehow satisfy the obligation to protect the environment. It is high time for the faltering COP process to be reinvigorated by a robust opinion from this court. The time for empty promises has passed. I now turn to the third point, namely that climate change poses an immediate, if not the greatest threat to human rights. In its resolution 56-8 of 10 July 2024, the UN Human Rights Council expressed extreme concern that climate change poses an existential threat to some countries and has already had an adverse impact on the full and effective enjoyment of human rights. This places climate-vulnerable states such as Bangladesh in an untenable position where human rights on their territory are adversely impacted by the conduct of other states. This implicates the interstate dimension of human rights obligations, including Article 2.1 of the Covenant on Economic, Social and Cultural Rights, requiring states parties to take steps individually and through international assistance and cooperation, especially economic and technical, to achieve progressively the full realization of rights. It is reinforced by the UN Declaration on the Right to Development, recognizing the duty of cooperation in ensuring development and eliminating obstacles to development. At a minimum, states must not impede another state's ability to protect and ensure the rights of its population. The fourth point is that these norms must be applied in conjunction with the principle of common but differentiated responsibilities. This requires developed states to mitigate emissions consistent with their greater financial and technical capabilities, even if all states must make mitigation efforts. This is a fundamental aspect of the equity that international law requires. I return to where I started. Each of these legal regimes leads to one overarching obligation to mitigate emissions to avoid breaching the 1.5 degrees Celsius threshold. This is the key obligation, as it is the only way to prevent the catastrophic harms predicted by the IPCC in a 2-degree or 3-degree Celsius scenario. But it is not enough. We are already at the 1.5 degree Celsius threshold. Even if all states immediately reduced emissions to meet their obligations, it would not undo the impacts already being suffered in Bangladesh, let alone stop future irreversible harms. This takes me to my fifth and final point. It is deeply unfair that countries like Bangladesh, that have contributed the least to global emissions, are paying the highest price, forced to make enormous investments to adapt to the catastrophes caused by high-emitting states. Mr. President, distinguished members of the Court, behind the abstract legal questions that are before you, beyond the walls of this great hall of justice, is a world of immense suffering. The momentous words that you weave in this historic opinion should guide states away from the precipice, and it should give hope to those who despair from this injustice. It calls to mind the words of the legendary Bengali poet Rabindranath Tagore, "I shall weave a chain of pearls with my tears of sorrow." This concludes my remarks. I thank you for your kind attention, and I ask that you please invite Ms. Amirfar to address you.
I thank Professor Akhavan. I now give the floor to Ms. Catherine Amirfar. Madam.
Mr. President, honorable members of the Court, it is a true privilege to appear before you on behalf of the People's Republic of Bangladesh. I'll address the set of specific obligations in respect of climate adaptation in light of what has already been said about harmonization. I turn first to the relationship between mitigation and adaptation. Adaptation has received less attention from participating states and international organizations in their written submissions. But even as mitigation remains central to preventing harm, for climate-vulnerable states like Bangladesh, ensuring that the necessary steps are taken to adapt to current and unavoidable future climate impacts is equally important. As we begin these historic proceedings, we face a stark reality. Negative climate impacts are already devastating Bangladesh and climate-vulnerable states. The international consensus on the best available science demonstrates that, given where we stand today, even effective mitigation of GHG emissions is not enough to remedy these impacts or prevent further negative impacts, which the IPCC concludes will continue to worsen even under a 1.5 degrees Celsius scenario and reach catastrophic levels at a 2 degree or 3 degrees Celsius scenario. In addition, according to the IPCC, in many instances, the extent of the climate crisis means that, quote, limits to adaptation have been reached, so that even with adaptation measures in place, not all loss and damage will be prevented. Accordingly, the best available science tells us that climate adaptation measures are equally essential part of the response to existing and unavoidable future harms. As multiple states acknowledge, adaptation-related obligations are primary obligations. They are not alternatives to mitigation, but are required in parallel, and in some circumstances, the same measures may be required in relation to both. For example, measures supporting ecosystem resilience as a means of adaptation, such as restoring wetlands to provide a barrier to sea level rise, also create carbon sinks in support of states' mitigation obligations. ITLOS confirmed this point in the context of states' customary obligation to protect and preserve the marine environment. At the same time, adaptation measures are also secondary obligations that can arise when states violate their obligations to mitigate GHG emissions in line with the best available science. Where unmitigated GHG emissions cause harm, for example, by increasing the frequency and strength of devastating weather events, then responsible states must assist injured states with the adaptation measures necessary to remedy that harm as a form of restitution or compensation. As such, states' adaptation-related obligations are preventive and responsive in nature and relevant to both questions A and B. Turning to my second point, the same legal framework underpins states' mitigation and adaptation obligations. This includes the core obligation under customary international environmental law to prevent and reduce significant transboundary harms related to GHG emissions, the duty of due diligence measured on an objective and stringent basis, the duty to cooperate to, quote, jointly manage the risks of damage to the environment, territorial sovereignty and self-determination, international human rights obligations, and express requirements in respect of adaptation under the UN climate change regime and UNCLOS. As in the mitigation context, adaptation obligations are informed by the best available science and subject to the principle of common but differentiated responsibilities. Accordingly, state-specific adaptation obligations will be based on their technical and financial capabilities and their historical contributions to climate change. At least 4 specific concrete obligations in respect of adaptation flow from this normative framework. First, developed states must take affirmative measures to ensure that the funds necessary to adapt to climate impacts are available and accessible. The IPCC has concluded that, quote, gaps exist between current levels of adaptation and levels needed to respond to impacts and reduce climate risks, end quote, and that at current rates of planning and implementation, these gaps will continue to grow. This is driven in part by the disparity between the costs of adaptation and currently available funds, particularly for developing states. At a minimum, then, existing financial commitments in support of climate vulnerable states must be met, but that is not enough. In line with the best available science and principle of CBDR, states must increase their financial contributions to levels necessary to meet global adaptation needs effectively. Some states argue that there is no enforceable obligation to increase financing, citing to the use of term goals in the UN climate change regime. But any argument that the UN climate change regime covers the field or otherwise displaces obligations under international law must be rejected for the reasons Professor Akhavan discussed. In addition, the undue emphasis placed on the term goals ignores the mandatory language used in other provisions of the UN climate change regime. Article 4.4 of the UNFCCC provides that developed states, quote, shall also assist, end quote, developing states in, quote, meeting costs of adaptation, end quote. The Paris Agreement is likewise not aspirational. Under Article 7.9, for example, all states, quote, shall, as appropriate, engage in adaptation planning processes and the implementation of, end quote, adaptation actions. Article 9.1 demands that developed states, quote, shall provide financial resources to assist developing country parties with respect to both mitigation and adaptation. And as confirmed by the ITLOS advisory opinion, Article 192 of UNCLOS, quote, requires states to implement measures to protect and preserve the marine environment that include resilience and adaptation actions as described in the climate change treaties. The tribunal specifically noted that, quote, measures of adaptation and resilience building frequently require significant resources, end quote, referring to Part 12 of UNCLOS, especially Articles 202 and 203, which require assistance to developing states. Second, developed states must cooperate by contributing relevant scientific, technological, technical, socioeconomic, and legal information to developing and climate vulnerable states, as required under the Paris Agreement and UNCLOS. The dissemination of clean and green technologies to climate vulnerable states at affordable costs is also required. This was originally contemplated under Agenda 21, adopted during the UN Conference on Environment and Development over 30 years ago. It has since been incorporated into decisions of the parties to the UNFCCC, Article 10 of the Paris Agreement, and is required by Articles 202 and 203 of UNCLOS. Third, states must take steps to preserve and restore climate-resilient ecosystems such as wetlands like mangrove forests. States must also comply with stringent due diligence obligations such as environmental impact assessments of public and private activities within a state's jurisdiction or control that may cause significant harm through GHG emissions, including cumulative effects. This also encompasses continuously monitoring environmental impacts to protect and preserve such ecosystems. Finally, states must take positive steps to fund or otherwise contribute to capacity building measures in climate vulnerable states to protect and ensure fundamental human rights, given that mitigation alone is insufficient to undo existing and avoid all future adverse impacts. For example, the IPCC has stressed the need to, quote, increase adaptive capacities to minimize the negative impacts of climate-related displacement, end quote, which is relevant to the nearly 20 million people at risk of displacement in Bangladesh. This might include, for example, measures to accommodate displaced communities and to build resilient structures to prevent future losses. I close my remarks by stressing the urgent need for adaptation measures to address the catastrophic effects of climate change. As you heard from the agent, millions of people in Bangladesh have already been affected. Millions more are at imminent risk. The devastating consequences for global peace and stability and human dignity flowing from the displacement of hundreds of millions of climate change migrants and refugees worldwide by mid-century is staggering to contemplate. The court's clarification of what states must do now as a matter of legally binding obligations to avert such a terrible future comes at a critical juncture for our world. Thank you, Mr. President, honorable members of the court, for your kind attention and your patience. This concludes the submissions of Bangladesh.
I thank the representatives of Bangladesh for their representation. I now invite the next participating delegation, Barbados, to make its oral statement before the court, and I call upon His Excellency Kerry Simons to take the floor.
Mr. President, Madam Vice President, honorable members of the court, I am Kerry Simons and I am Barbados' Minister of Foreign Affairs and Foreign Trade. Mr. President, Barbados has taken the unprecedented step of making 2 sets of extensive written submissions and appearing before you today for one simple reason. The climate crisis which lies at the heart of these proceedings is for us an imminent matter of life and death. It is not, Mr. President, a statistical matter. It is not a theoretical or speculative matter, but it is a matter of life and death, simply because of the fact that for people of small island developing states such as mine, there is nowhere to go when confronted with rising sea levels. There is no hinterland. There is no interior. There is no area of as yet unexplored territory. All that we have is 166 square miles of land for our 300,000 residents. Small islands like ours, Mr. President, are surrounded by coral reefs that play a key role in nurturing and protecting coastal communities and facilitating nearshore economic activities such as fishing and leisure. The sea is therefore not only the home to our biodiversity, but it is also the source of our nation's livelihood. Carbon emissions from human activity are causing ocean warming and acidification, which in turn places our coral reef and its entire ecosystem at extreme risk. As a consequence, everything, Mr. President, that we have painstakingly constructed as a nation and as a people is now placed at risk because of the climate crisis. The tourism sector, for example, which has buoyed our economic fortunes for the better part of a century, is now at risk. The fishing sector, which has been a sustainable source of protein for generations of Barbadians, thousands of Barbadians, Mr. President, is now at risk. The sugarcane industry, which we have grown for hundreds of years and from which we have distilled a world-famous rum, is also at risk. Mr. President and your honourable members, you have heard and will no doubt hear more about the record-breaking Hurricane Beryl, which passed through the Caribbean area earlier this year. Hurricane Beryl moved from being a simple tropical storm to being a Category 5 hurricane in approximately 24 hours. Hurricane Beryl struck Barbados and destroyed 90% of Barbados's fishing fleet, a fleet which had been hauled behind the protection of marinas and breakwaters which had existed for the past 35 years. However, such was the unprecedented intensity of the waves Beryl sent our way that those near 40-year-old protections proved insufficient, and marinas that had hitherto provided sanctuary became scenes of mass destruction. Destruction which is now estimated to cost over 100 million United States dollars to replace. 100 million United States dollars, Mr. President, of unplanned expenditure accruing to a micro-state with a micro-economy with 1 day's notice. What you might not have heard about is another startling example of the effects of climate crisis in the Caribbean, and I refer specifically to periods of prolonged drought. The first 5 months of the year 2023, for example, saw levels of rainfall which were 53% below the preceding 30-year average, below the preceding 30 years average for Barbados during the first 5 months of those years. Storms like Beryl, periods of prolonged drought, slow onset phenomena such as sea level rise and rising temperatures are the catastrophic new normal which has become our lived reality. Mr. President, the economic consequences are no less palpable than the environmental consequences to which I have just referred. Even as productive sectors are being affected, the ability of the state to provide support is undermined by rising cost of finance and increasingly the challenge of securing sustainable insurance. This challenge exists because insurance companies themselves are now becoming more risk-averse in the face of more frequent, more powerful, and more devastating storms. So that my country, therefore, like some regions in larger countries, is now in grave danger of becoming uninsurable. And it follows logically, Mr. President, that without the ability to access or sustain insurance premia, a country's economy will also then become uninvestable. Barbados contends, and science clearly demonstrates, that these are the consequences of this man-made climate crisis, a crisis towards which Barbados and small island developing states have contributed almost nothing, but which may take away everything that we have. Mr. President, honourable members of the Court, Barbados is a firm believer in the international legal order, and that is why 44 years ago we accepted this Court's compulsory jurisdiction. Today we appear for the first time before this Court respectfully to request clear answers to clear questions posed unanimously by the UN General Assembly. The serene picture of Barbados, Mr. President, I leave with you with the words of one of the Caribbean's most famous poets, Barbadian Kamau Brathwaite, in his poem South. He says, bright waves splash from the rocks to refresh us, blue seashells shift in their wake, and there is the thatch of fishermen's houses, the path made of pebbles, and look, small urchins combing the beaches, looking up from their traps to salute us. Fishermen hawking the surf on this side of the reef, stand in their boat and hallow us. That serene picture stands to be obliterated if we do not cease the forms of global conduct which will leave our island uninsurable, uninvestable, and ultimately uninhabitable. Mr. President, I request to be followed sequentially by Ambassador Francois Jackman, Barbados's co-representative, Professor Robert Volterra, co-representative, and Mr. Gunjan Sharma, External Legal Counsel for Barbados.
I thank His Excellency Kerry Simmons. I now give the floor to His Excellency Francois Jackman. Sir, you have the floor.
Mr. President, honourable members of the Court, I wish to speak briefly about the international context surrounding the climate crisis and to highlight a key initiative taken by the Government of Barbados to address these challenges. You will be aware that many countries and advocates in the fight against the climate crisis were deeply disappointed by the recent outcomes of COP29 in Baku. A target of $300 billion per annum for climate finance was agreed, whereas it is generally accepted that $1.3 trillion per annum is in fact required. We agreed in the Paris COP21 almost a decade ago that as an international community, we would seek to limit global warming to 1.5 degrees centigrade above pre-industrial levels. Today, we are headed well past this point with continued growth in greenhouse gas emissions. Barbados, like many other countries, had put great faith in this negotiation process and in the undertakings of the states. To say that we Barbadians are disappointed is to measure the distance between what has over the years been promised against what has in fact been delivered. The massive gaps between promise and delivery are at the heart of the climate crisis for developing countries in general and for small island developing states like Barbados in particular. It is to address the climate financing crisis in particular that Barbados has piloted the Bridgetown Initiative. Monsieur le Président, Mesdames...
Mr. President, honourable members of the Court, the climate financing crisis is intimately linked to the chronic insufficiencies of the global financial system. That's a system which, in the view of the UN Secretary-General himself, is absolutely not up to the task. Let me quote him. Instead of having a safety net, developing countries are confronted by an obsolete system which is both dysfunctional and unfair and which does not meet their needs. End of citation. So, Barbados put in the heart of its diplomacy the Bridgetown Initiative. Now that aims at reforming from the bottom up the global financial system with specific regard to climate change. International financial institutions such as the World Bank and the IMF would thus be fully able to fulfill their function to support countries in the implementation of the Sustainable Development Goals as set out in UN Agenda 2030. These institutions, together with other institutions and financial instruments such as regional development banks, the private sector, including insurance companies, levies on a certain number of industrial and economic activities, and the philanthropic sector, will thus be able to fill this vast and perilous financial shortfall to which I referred. Mr. President, distinguished members of the Court, as a conclusion, I would like to repeat a conclusion which, in a principle, for my country is of signal importance. We're not here today looking for a handout. Rather, as we have stated in our written statement, we seek justice. Those states which are responsible for climate change have the obligation under international law, as will be explained in greater detail by my colleagues, to provide complete and effective reparation for this harm. A renewed and reformed financial system, as proposed by the Bridgetown Initiative et al., is one of the key elements of this justice.
I'll ask the Court to call upon Professor Robert Volterra, co-representative of Barbados, to continue Barbados's submissions. I thank you.
Je remercie l'ambassadeur François Jacquemin and
thank you, Ambassador Jacquemin.
Mr. Robert Volterra.
Mr. President, Madam Vice President, judges, it is an honor to appear once again before this court. I make submissions today in my capacity as co-representative of Barbados. Barbados has submitted 2 written pleadings in these proceedings. They are 332 pages long. They contain over 1,000 citations. These include 84 scientific papers, 54 academic citations, and 505 legal authorities. Barbados reaffirms its written submissions, but of course it's not possible to summarize them today. Therefore, in its remaining time, Barbados will focus on 4 submissions. They concern 1. The applicable law, 2. The doctrine of strict liability, 3. Causation and attribution, and 4. Foreseeability. I will address topics 1 and 2. My colleague Gunjan Sharma will address topics 3 and 4. I turn to my first submission, that is, the applicable international law. This is arguably the core issue before the court in this advisory opinion proceeding. A number of states argue here before you that you should ignore every source of international law except 3 treaties. Barbados submits that the entire corpus of international law applies to climate change. All of the sources of international law identified in the court's statute are relevant. The UNFCCC, the Kyoto Protocol, and the Paris Agreement are not exhaustive statements of relevant international law. They are not a lex specialis. And despite repetition of the words, they do not create an exclusive self-contained legal regime. Nothing in their texts, nothing in the text of these 3 treaties lead to such a conclusion. Barbados's position is that these 3 treaties do not displace other international law. Now, I invite the court to consider the slide you see before you. It shows a map of the world. The states whose formal, official, binding pronouncements confirm Barbados's position on the applicable law are highlighted on this map. This map illustrates the evidence set out in Barbados's written pleadings. For example, no less than 15 states declared during the negotiations leading to these 3 climate change treaties that they complemented, not that they superseded, not that they displaced, but that they complemented existing international law. No state objected to those declarations. As the court is aware, in the submissions to this advisory opinion proceeding, numerous states have also confirmed that same view. And numerous states have made official pronouncements confirming that these 3 climate change treaties are only a starting point. Japan is one such example. Finland is another. Finland noted that the UNFCCC only, quote, sets the stage, end quote. Likewise, Australia elsewhere said the Kyoto Protocol only, quote, lay a solid foundation, end quote, on which to build. In this proceeding, the European Union argues that these 3 treaties are the principal source of climate change law. The EU also asserts that they displace significant parts of international law, such as the international law obligation of redress. Notably, however, individual member states of the EU have disagreed with this position. They have historically and repeatedly expressed contradictory positions to the EU's current position before you in this case. For example, in 2005, the Netherlands, the country in which we are now, speaking on behalf of the European Union, told the United Nations General Assembly that the Kyoto Protocol provides only, quote, an additional legal basis for international efforts to address climate change, end quote. 3 climate change treaties may or may not have been a starting point, but there is no tenable legal or factual basis to conclude that they are the only or the ending point. This calls to mind the phrase, quote, better hope deferred than none, close quote. But that being so, I invite the court to consider how much more compelling is the proposition, quote, even better hope fulfilled than deferred, close quote. I turn now to my second submission, speaking in French.
In my second presentation, Barbados will look at the reasons for which the obligation to provide reparation for harm caused by climate change falls under the regime of strict liability. Now, in these proceedings, some states have argued that the obligation to refrain from causing transboundary harm is an obligation of means. Now, this assertion is incorrect. It's much more an obligation of result. It is the harm alone which gives rise to the obligation of reparation. International law surely does not envisage the following inconsistencies: that GHG emitting states obtain all the material and economic advantages accruing from climate change, or that developing countries, small island states, suffer the adverse effects of climate change. Or again, that developing countries and small island states may solely rely on ex gratia payments from emitting states to mitigate this harm. Mankind's oldest laws recognize the concept of strict liability. For example, the old Hindu code, the Manusmriti, established a regime of strict liability. It imposed an obligation of compensation for transboundary environmental harm, be it caused, I quote, intentionally or unintentionally, end of quote. The Sharia, the words of the Prophet Muhammad, peace be upon him, all take the same line. Pursuant to a general legal principle in contemporary national legislations, an entity sees its strict liability engaged for harm resulting from its hazardous activities. The draft principles of the ILC on the allocation of loss in the case of transboundary harm arising out of hazardous activities also endorses this principle. These provide for compensation on the basis of strict liability when, I quote, hazardous activities are undertaken, end of quote. Now, climate change is caused by a hazardous activity to which the following hazardous acts: digging a hole, be it large or long, either in the ground or in the seabed; pumping or extracting the planktonic necromass and or certain tree matter; chemically refining the above; placing these refined bodies in a metallic cylinder and then causing the mixture to explode by a spark, and then expelling the waste to float freely in the atmosphere. It's hazardous. As of 1965, lawyers and jurists such as Wilfred Jenks explained that hazardous activities gave rise to strict liability under international law. Now, his statement came 2 years after, only 2 years, but 2 years nonetheless, after the US National Academy of Science had informed President John F. Kennedy of the existence of fossil fuel-induced climate change. The ubiquitous extraction and use of fossil fuels by certain states in no way calls into question the fact that it's a hazardous activity. It is hazardous. In any event, as Barbados pointed out in its written observations, some states became aware of climate change well before 1990. My colleague Gunjan Sharma now will deal with this in greater depth, but these factual elements demonstrate in conclusive fashion that those states, originators of climate change breached every possible applicable obligation of reasonable due diligence. Thank you very much, Mr. President, distinguished members of the Court, for your kind attention.
Thank you, Mr. Volterra.
Thank you, Mr. Volterra.
To Mr. Gunjan Sharma.
Mr. President, judges, it is an honor to be before this court again. This time I appear on behalf of Barbados, and I will be making two submissions today. In my first submission, Barbados will respond to two related yet incorrect arguments that certain states have made in this proceeding. The first argument, that climate change is too far-reaching to be causally linked to any one state. And the second argument, that too many states contributed to climate change, so no one state is liable. On the first argument, some states argue that the causes and impacts of climate change are too complex and too far-reaching to be attributed to any one state in a causal sense. I.e., they say, if climate change does so much harm, how can any one state be linked to it? The fact that climate change causes global harm is a matter of scope, not causation. States exist on this one planet, and their behavior often impacts the whole planet. As the playwright Samuel Beckett once explained, "You're on Earth. There's no cure for that." As to cause, the cause of climate change is simple, it is direct, it is foreseeable, and it is not remote. Climate change is caused when expelled pollutants heat the atmosphere by trapping infrared radiation that would otherwise leave the planet. It's that simple. On the second argument, each major emitting state individually cannot avoid its obligation to provide redress simply because all the major emitting states acted together to cause climate change. Under international law, states are liable for common wrongful acts and harms, and the obligation of redress is joint and several. Nor does international law require that redress is only due when it can be calculated with exacting precision. This court and others have explained the opposite on many occasions. Of course, the purpose of these proceedings is not to place blame on any state in concreto, but the General Assembly asked this court to determine the legal consequences for states who have harmed the climate system. This court should clarify that one such consequence is the obligation of redress. I turn now to my second submission concerning foreseeability. In 1990, the IPCC published its first report. Even earlier today, certain states have argued that climate change could not have been known by any state until that report was published in that year. Barbados will now show that that is factually inaccurate. Barbados reiterates, the purpose of this proceeding is not to assign blame. However, this court should act on correct historical information. Barbados seeks to correct the historical amnesia that often pervades climate change discussion. And in this respect, the year 1990 is legally irrelevant. The major emitting states, many of them, knew about climate change decades before that year. For example, turning to the slides that will appear before you, in 1962, the U.S. National Academy of Sciences confirmed to President John F. Kennedy that the extensive use of fossil fuels would disrupt the weather and ecological balances. Next slide. As Vanna Attu mentioned earlier today, in 1965, U.S. President Lyndon B. Johnson explained that to the U.S. Congress. In 1968, senior French interministerial officials, competent officials, were also briefed on climate change. In 1970, the UK Parliament discussed climate change. In 1974, the very first sentence of a U.S. Central Intelligence Agency report said, quote, "The Western world's leading climatologists have confirmed recent reports of a detrimental global climatic change." The Central Intelligence Agency then predicted climate change would cause, quote, "drought, famine, and political unrest." In 1975, the Soviet Union and Americans confirmed climate change again. And in 1978, the Western Parliamentary State Secretary confirmed climate change to the Bundestag, noting also the responsibility, that's a translated word, responsibility of industrialized countries to shift away from fossil fuels to environmentally friendly energy sources. That was 1978. Our printed slides have more examples. This incontrovertible evidence leads to an unfortunate conclusion. Many major emitting states knew what climate change would do for 80 years. They knew about all the consequences that have been described to this court in these proceedings. Worst of all, many major emitting states knew that all of our lives, the lives of every one of us on this planet, would become shorter, more brutish, and poorer because of their decision to promote the use of fossil fuels. Major emitting states knew that they were creating a global future of, quote, drought, famine, political unrest, as the CIA established as long ago as 1974. These states even knew that climate change would shorten the lifespans of their own future citizens. But to make a few more dollars in rubles or francs and Deutschmarks, these states did it anyway. They chose to do it to all of us anyway. And now they are asking this court to forget what really happened. They are asking this court to forget what they really did and what they really knew and when. Barbados thanks the court for its kind patience and attention.
I thank the Representative of Barbados for their presentation. This concludes this afternoon's sitting. The oral proceedings will resume tomorrow at 10 a.m. in order for Belize, Bolivia, Brazil, Burkina Faso, Cameroon, and the Philippines to be heard on the questions submitted to the court. The sitting is closed.